This is Chair Douglas. For the record, we're calling the Cannabis Compliance Board meeting February 28th, 2023 to order. Our first order of business is our quorum.
Member Merritt. Member Durrett.
Present.
Member Freilich.
Present.
Dr. Young.
Present.
Justice Douglas.
Present. Note for the record that our newest board member, Adriana Freilich, is present in attendance. Dennis Nylander resigned from our board, so this is her first official board meeting. She participated earlier in the month in some other things, but we welcome her aboard. With that, we open our meeting with item number 1, public comment. If we have any in Las Vegas who wishes to make public comment, please come forward, identify yourself, and we await your statement.
Good morning, board. My name is Jason Greninger, Greninger, and I just want to reiterate our need for managing our COA database and its needs for moving medicine.
You speak very soft, so it's hard for our reporter to pick you.
Thank you. Appreciate it. I can move this a little bit. Thank you. Just wanted to reiterate the importance of the need for our COA database and how that will move medicine and process further in Nevada and our needs for that. Turns out our bodies make over 150 endogenous cannabinoids, which are retroactive neurotransmitters. These go into nucleus and create change, and they manage our body's equilibriums, sleep, anxiety, diet, such. These are our own keys that manage our equilibriums. Now, there's no other plant out there that makes the same endogenous or copies of our endogenous keys. The cannabis plant makes up to 144 phytocannabinoids that match and mimic our keys for equilibriums. And I have personally seen some very miraculous cures with concentrates applied. It's a very random process, and the medicine to go forward involves looking at those variables at a deep level and comparing them with outcomes until we have a COA database to start looking at the variables to each product and compare those with process and outcomes. Well, we're only getting high. It's fun. It's nice. I like that too. But the truth is medicine doesn't go forward unless we actually look and quantify variables in process and outcome. And we do need a database to do that. If we set this up right, that database will have research quality data that NIH can use, that the rest of the country can use, actually look into and even do retroactive cohort studies into our products. And every product in our dispensary would have enough data in it to be of research quality. It's important that we know and move forward on this because this plant is connected to us at a way no other plant is. And it's just we're the symbionts to this plant. And if you think about it, its seed doesn't land beyond its own footprint unless it makes one of us happy. Well over 2,000 years we've been tied to this plant. So what we decide to do in medicine and the change we're going to see shortly with potentially Schedule 1 in Nevada, this research is vital. And we can move Nevada to the forefront of medicine in cannabis if we do this right. Thank you.
Do we have anyone else in Southern Nevada who wishes to make public comment this morning? Seeing none, in our Northern Nevada site, snow and all, and things being shut down, do we have anyone who wishes to make public comment in the snowy north? Not hearing any, we'll move our agenda then to item number 2, which is meeting minutes. We have consideration for approval of the January 24th, 2023 Cannabis Compliance Board meeting minutes.
Mr. Chairman, I just have a disclosure if I could.
Please.
I have reviewed the minutes. However, since I was not present, I just want to abstain from voting on this item.
Thank you. So noted. For the other members of the board, if they're ready, if we can have a motion.
Chair, I was going to move to approve just item A because I also was not present
That's
during
the-
item B.
Yes,
I move to approve, Member Durant, for the record, I move to approve item 2A, consideration of the minutes from the January 24th, 2023 meeting.
and just for clarity, we would be taking separately the A and B items. This would be the A item only. We have a second for approval of the A item.
Member Young, I'll second
Member
that.
Merritt, I second.
Been moved and second. Any discussion or corrections to the minutes? Hearing none, all in favor, please say aye.
Aye.
That moves us to item B, and as to item B, it's consideration for approval of the January 24th, 2023 Cannabis Compliance Board Emergency Meeting minutes. And the only two members who are in a position to approve them would be Member Merritt and myself. So I do note that,
Member Merritt, for the record, I move to approve.
and I would second.
Rosalie Bordelove for the record. We need one more vote to approve them. However, if you weren't present, you can simply vote to say these are the minutes, the official minutes of the meeting, even if you are not attesting to their content. You are trusting staff for the minutes themselves.
And I can do that.
Is that three? We only have three.
I think we just had a vote from Board Member Freilich.
That's correct.
If that be the case, now that you've stated that clarity, in favor of approval, please say
Aye.
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 Matter carries. That moves us to our consent agenda. It's on for consent, but if any member wishes to have any item held and heard separately, we can do so. So does anyone on the board wish to have any of the items under item 3, 1 through 10, heard separately? I have a question of Greenleaf Farms Holding. I would like to hear from them. A slight question, but before I do that, any other board member wish to hear any of those items separately?
No.
If not, if we can have a motion for approval as items 1 through 10, omitting item number 4 at this point, Greenleaf, for approval.
Member Durant, I move to approve the consent agenda items under agenda item 3A, except agenda item 4. So it would be items 1 through 3 and items 5 through 10.
Member Merritt, I second it.
Been moved and seconded. Any additional discussion?
More specifically, the final inspection deadline would be moved to, we're doing February 23rd, 2024?
I think it's November. I keep
Okay,
thinking-
November 5th of 2023. Okay, so more specifically, the deadline would be moved to November 5th, 2023.
So we now have a motion. Do we have a second?
Member Merritt, second.
Moved and second. Any other discussion? Hearing none, all in favor, please say aye.
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 Motion carries. I had singled out Greenleaf Farms Holding. And I'm hoping what I did was correct. Do we have anyone here from Greenleaf? Please come forward.
Everybody?
Good
Bradley.
morning. The only question I had was not opposed to your motion for extension, but clarification. If I hit the the proper one. There were some legal proceedings that were going on.
Yeah, that's going to be ongoing for a long time. That's not the reason we're held up. We
No,
just,
that was part of my question, what the status was. with that.
legal proceedings going to go on. It could go on for years. There's 2 different cases going back and forth. There's appeals. I don't know for the proper legal terminology to tell you, but it's long drawn out.
That was part of the concern, whether or not it was something that might be resolved in the next year, whether it was, you thought it was going to extend.
I believe it'll be resolved this year in our favor.
Okay.
Otherwise, I wouldn't be investing all the money into getting up and running if I wasn't confident.
Appreciate it. Any other board member have any questions? If not, if we can have a motion for approval.
Member Drat, I move to approve consent agenda item 3A for the extension for Greenleaf Farms Holdings. The extension will be till November 5th, 2023.
Thank you. And can we have a second?
Ms. Mon
Member
Freilich, I
Merritt,
second the motion.
Thank you. We have a second. Freilich. Any additional questions or discussion? Hearing none, all in favor, please say aye.
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 Thank you very much.
Mhm.
Nice day.
Moves us to item number 4, consideration of proposed settlement agreements, resolve disciplinary actions. The first matter up is item A, Cannabis Protection Board versus Faith Crosby, case number 2022-58.
Thank you. For the record, I'm Emily N. Bordelove, Senior Deputy Attorney General for item 4A. As outlined in the stipulation in order before the board, this matter relates to a series of underage sales that occurred through a dispensary's drive-through. That dispensary and those employees involved in those sales have been disciplined by the board previously. The incident involving Ms. Crosby did not result in a sale. It occurred after those underage sales through the drive-through, when that same underage person entered the dispensary and Ms. Crosby unintentionally allowed her into the dispensary. The complaint, filed and served on February 28th, 2022, alleges that Crosby failed to verify the age of an individual under 21 years of age by ignoring the Veriscan notification that the individual was underage and allowing a person who is less than 21 years of age to enter or remain in a cannabis establishment. The complaint further alleges that those actions constitute grounds for either one Category 2 violation under NCCR 4.0401A3 or 4, which carries civil penalty of not more than $25,000 and a suspension of the license or agent card for not more than 20 days, and or one Category 3 violation under NCCR 4.0501A7 for allowing activity which violates the laws of the state, which carries a civil penalty of not more than $10,000. After service of the complaint and attempts to contact Ms. Crosby, Crosby did email the CCB regarding the complaint. CCP's counsel attempted to contact her via email and was able to conduct a courtesy call with her regarding resolving the matter. During this call, regarding the allegations in the complaint, Ms. Crosby did not deny that she allowed an underage person into the cannabis establishment, but did say that she was in training at the time, was overwhelmed by the number of customers, and that she attempted to alert her coworkers as soon as she discovered her error. Counsel for the CCB asked Crosby how she intended to proceed with disciplinary matter, and at the time of that call, Crosby explained that she did not have any money and would not be able to pay the civil penalty. She also expressed that she had no intention of returning to Nevada at that time or working in the Nevada cannabis industry. She offered then to give back, in other words, surrender her agent card to the CCB to resolve the case. After obtaining approval to accept Crosby's offer to surrender her agent card for 9 years and 11 months with no imposition of civil penalty, given her represented economic hardship and representation that she had no intention at the time of returning to work in the cannabis industry in Nevada, parties entered into a proposed stipulation order of settlement, disciplinary action to be presented to the board at the July 22 board meeting. At no time before that July 2022 board meeting did Cosby express concern with, requested to withdraw, or reconsider the proposed settlement agreement to CCB's counsel. But Cosby was not represented by counsel at the time. As memorialized in the transcript and video of the July board meeting, counsel for the CCB noted that Cosby presented mitigating factors mentioned earlier and had offered to surrender her agent card, given she stated that she no longer resided in Nevada and communicated that she had no intention of returning to work in the cannabis industry in Nevada. Cosby, however, recanted her prior representations, and after her testimony, the CCB's chair requested further investigation into the alleged violation in the complaint. Sometime after the July board meeting, Cosby retained counsel, Maggie McClatchy, who's here on Cosby's behalf. An answer was filed, and the matter is currently stayed to allow finalizing of the settlement agreement for you. As represented in the stipulation order before the board, the parties have agreed to the following terms. For the sole purpose of settling this matter, Cosby acknowledges that the facts contained in the written fact sections of paragraphs 1 through 23 of the stipulation and order are true and correct. Without waiving any constitutional rights against self-incrimination, Cosby further acknowledges that specific facts contained in the complaint in case number 222-058 could be found to constitute violations of Title 56 of the NRS and the NCCR, with penalties up to and including a civil penalty of $25,000 if this matter went to an administrative hearing. As indicated in paragraph 29 of the stipulation order for the board, in settling the matter, the executive director for the CCB and counsel for the CCB have considered the factors set forth in NCCR 4.030 subsection 2. The executive director and CCB counsel for the CCB, in both this and the prior settlement agreement, considered the impact of the civil penalties on Cosby, given her professed economic hardship and the fact that she was not working. The prior settlement agreement contemplated revocation of or surrender of Cosby's agent card for 9 years and 11 months, given her representation that she no longer resided in Nevada and had no intention of returning to work in the cannabis industry. Now, given what occurred at the July board meeting and Cosby's retention of counsel to mitigate any apparent misunderstanding of her professed intentions, counsel for the CCB and Cosby's counsel negotiated the terms of the stipulation and order as follows. For the sole purpose of resolving the administrative action, Cosby admits explicitly to unintentionally allowing an activity that violates the laws of the state under NCCR 4.050187, a Category 3 violation with respect to the underlying complaint, and further agrees to the following. Cosby's current agent card is not active as it expired in December of 2022. Instead of suspending an expired card, Crosby has agreed that she may not apply for a new agent card for 1 year, starting from the date the board approves the stipulation. If after the 1 year suspension concludes and Cosby chooses to apply for a new agent card as part of her corrective action and before applying for a new agent card, she shall complete online course or training on age verification and review Title 56 of the NRS and NCCR, any amendments thereto, with an opportunity to consult with counsel of her own choosing regarding the same if she does not understand any of the statutes or any regulations she's reviewed. Cosby's completion of these corrective actions will be confirmed by the declaration attached to Exhibit 1 to the stipulation and order before you, and executed by Cosby that she will submit to the CCB before and if she applies for a new agent card. Based on the facts of this case, the foregoing corrective actions and admissions, the Attorney General recommends and requests the CCB approve the settlement. As noted before, Cosby's counsel, Maggie McClatchy, is present, and Ms. Cosby is here via Zoom to answer any of the board's questions. With that, I submit.
Thank you. Good morning. Representations.
Good morning, Maggie McCletchy for Ms. Cosby. I think this is a fair and appropriate settlement, and I'm happy to answer any questions.
Board member wish to ask questions. We've been back and forth on this item and seem to have a resolution this time. Everyone agreeing.
Member Durrett. So I wasn't so concerned on the last one that she was saying it was unintentional and the state was saying maybe something different, because I think the state was doing everything in good faith. I think that she maybe didn't portray what had happened correctly the first time. I'm more concerned about going after an employee that clearly made a mistake, but immediately tried to correct it. And I want to add one more thing. I just want us to always maintain a little perspective. And I was walking through a casino with my kids. We were going to eat somewhere, and I look over, and the little puppy that we have at home, the little stuffed animal puppy, was on a shelf in a casino, and kids are walking through there. So minors are not allowed. We, of course, need to be vigilant on that. Of course, no sales to minors. I just think we need to keep some perspective about it was really this person's fault. This person tricked this establishment. But I will support it mainly because I know if Maggie McCletchy is saying it's fair, she would not be recommending this settlement if it was not fair. My Twitter feed is full of her winning at the Supreme Court, the Nevada Supreme Court, going against the state, going against authorities all day long. So if she recommends this, then I'm supportive of it.
For the record, Maggie McCletchy, I just want to point out a couple of things. First of all, I want to thank Ms. Bordelev for working with me and Ms. Crosby, including in coordinating with Ms. Crosby once I offered to be pro bono counsel. And I think that this case illustrates that there was some confusion on the part of Ms. Crosby. This result, in my view, is a lot more fair because rather than her giving up her economic ability to return to Nevada for almost 10 years, she's able to return after 1 year, so long as she meets the requirements set forth in the settlement agreement. So the concerns about that the CCB had are also met because she'll be able to go through training and make sure that if she does decide to come back and try to become an agent again, that she will comply with all applicable statutes and regulations, and something like this won't happen again. But I also wanted to point out that I offered to do this, and I think there is an issue with employees don't have the same representation as some of the establishments. Ms. Ashcraft, I think, is here today through the cannabis law section of the state bar. She and I are actually trying to implement a program by which other employees, if they can't afford an attorney, can also get assistance, because I believe that not only does it help the employee and make sure that justice is administered fairly, I also think, frankly, it helps the board and the Attorney General's office work through these matters more efficiently.
Chair Douglas, for the record, this is kind of for those who were not privy to it previously, this was a drawn out matter. One of the concerns, as usual, is sale of cannabis to underage individuals. That's what precipitated this particular matter. And as you rightfully point out, counsel, the concern is proper training by the establishment, them upholding rules and regs, and the employees being properly instructed on how to do it. We called it because the individual, when she came in the first time, wanted to recant from the agreement. We sent it back. We've had further proceedings. We appreciate the pro bono service that was provided to the individual. And what we are trying to do is make sure that we are consistent. We understand the adversity of individuals who are working, but again, the two things to remember is being fair to the person who appears before us for an alleged violation, and secondly, upholding the rules that are put in place as to whether or not minors are allowed to receive cannabis. So we have a fair resolution. It's been signed off by Ms. Crosby. Unless board members have anything else to say, we get a motion for approval of the settlement.
Member Durrett, I move to approve the settlement agreement under agenda item 4A between the CCB and Faith Crosby.
It's been moved for approval. Do we have a second?
Ms. Member Young, I will second that.
Been moved and seconded. Any additional discussion? All in favor, please say aye.
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 That carries unanimously.
Thank you very much.
Thank you. Moves to our second item, item B, Cannabis Compliance Board versus NLV Wellness LLC, case number 2022-63.
Good morning, Chair, Members of the board, L. Christopher Rath, Senior Deputy Attorney General. I will be presenting the second settlement agreement up for approval today. Before I do that, I would like to introduce the board to our new Senior Deputy Attorney General, Allison Herb, who is seated to my left here, and would just welcome her to our team.
Thank you. And welcome.
Proceeding on, under agenda item 4B, we have the case of CCB versus NLV Wellness LLC, CCB case number 2022-63. This licensee, NLV Wellness, is a medical and adult use cannabis cultivation facility. The complaint in this case was filed on October 13, 2022. Respondent filed an answer generally denying the allegations on November 9, 2022. The disciplinary process was then initiated and proceeded with the CCB's hearing officers. CCB hearing officer. The parties proceeded and exchanged their initial document and witness lists. The allegations in the complaint arise from several audits and inspections. The first was in May 2021, in which CCB agents found multiple untagged cannabis plants and products, issues with destruction logs, individuals working at the facility without valid agent cards, and some issues with building disrepair. An order of summary suspension was issued in May 2021. After several plans of correction were issued, an untagged product was destroyed by agreement with the licensee. The board lifted the summary suspension in June 2021. In addition, there was some later issues with a metric cleanup request in August 2021, which involved some unexplained inventory variances. Another routine inspection in July 2022 found a number of cannabis plants untagged, which was corrected, and some building disrepair issues, as well as an individual working at the facility with only an expired temporary agent card. All of those foregoing issues were covered in the disciplinary complaint at issue in this case, and board members do have a copy of that in their materials. However, during the course of the disciplinary proceedings, the parties did engage in good faith settlement negotiations and eventually came to agreed upon resolution of this case, which is set forth in the settlement agreement before you. As indicated in paragraph 10 of the settlement agreement, we did consider the factors set forth in NCCR 4.030 subsection 2 in determining the appropriate admissions and civil penalties. More specifically, despite compliance history and some repeat issues, respondent did cooperate with CCB staff in ceasing operations during the summary suspension, voluntarily destroyed untagged cannabis, and put forth plans of correction to remedy the issues and to try to prevent them in the future. Respondent and their counsel also cooperated with CCB's counsel in coming to a negotiated resolution of this case without the need to go all the way through the disciplinary process, and thereby saving resources for the state. In addition, the parties agreed to a payment plan for the civil penalties, which will allow for full payment and also take into account the timeline of respondents' harvests and receipt of revenues from those harvests. As set forth in the proposed settlement agreement, to resolve these matters, respondent admitted to 2 Category 3 violations for failing to tag plants as required, 2 Category 4 violations for agents failing to have valid agent cards in their possession, and 2 Category 5 violations for multiple building repair issues. Respondent also agreed to pay civil penalties in the amount of $154,000. As I noted, this is on a payment plan as noted and set forth in paragraph 18 of the agreement, which also includes a payment schedule. If the board approves this agreement, respondent will pay $14,000 a month for 11 months and can prepay any installment without prepayment penalty. The first payment would be due on March 15th. Respondent also provided multiple plans of correction, and those are all detailed in paragraph 20 of the settlement agreement, and CCB staff has approved those plans. Those are lengthy plans. There's 12 items detailed, but I'll just go through some of the key points. Number one was there was destruction of the untagged plants and product, which was voluntary. They put in place training procedures for employees on the need to properly maintain agent cards. There was the retention of regulatory counsel for compliance review and advice. There were plans and training on improving metric compliance. And the licensee updated standard operating procedures on weighing and measuring cannabis with training for employees on the new standard operating procedures. The corrective action plans and proposed resolution is acceptable to the CCB staff. And based on the foregoing, the Attorney General recommends and requests the CCB approve the settlement agreement. I'm available for any questions, as is the respondent and his counsel.
Thank you. We have our representations of council for the licensee.
Thank you. Board members, Robert Wodicki on behalf of NLV Wellness. Also with me is Salman Ali of NLV Wellness, available for any questions you might have.
Any representations you wish to make for this one?
No, Your Honor. Just that was an accurate representation of the settlement that was reached, and I appreciate what the CCP staff did with us. Again, any question the board might have.
Questions by board members?
I have a couple questions. First, for the AGs, it appears that the state's perspective was likely that this was mismanagement, non-compliance, not that they were not tagging it because they wanted to sell it on the illegal market, right? Otherwise, it would probably be a much different approach and allegations, right?
I think that's fair. There was issues with tagging and not tagging, but they were able to correct it. They were cooperative in the whole summary suspension issue, and we looked at all their plans of correction. Yeah. I mean, there's no intentional violations that were put in the settlement agreement.
And then looking at the factors under 4.030, when determining a civil penalty, I think the ones that are most relevant are, I'm assuming it's a relatively small grow and the amount is really high. But I'm assuming since you're entering the settlement agreement that you believe that these are affordable. It specifically says that take into consideration the effect of the penalty on the business, the economic benefit. No, I'm sorry, that wouldn't be relevant. So the effect on the business. How's that going to work in practice?
To be honest, I mean, this is pretty much crushing me, but it's what was recommended as opposed to $400,000. You know what I mean? So we really have no other choice but to accept what was negotiated.
And probably, I'm trying to remember, revocation would be on the table too, right? Was there a category one?
There was an awful lot of untagged plants and products here. Probably total up over 1,000. I mean, even in the latest issue, there was over 400 untagged products, which, they were able to find the tag.
Not true. All those plants were 100%.
I'm gonna let your attorney take a second to tell you to give you some advice real quick. Or I'll let the chair handle that. But I feel like there's no good answer on this because this fine, I think, is deserved. But if you look at the factors of whether or not of the economic impact, if this is a small grow, we don't have your financials in front of us. Can you afford this? Will this put you out of business? And then this isn't your guys' situation, but potentially if you have a small grow with a high fine that could push into selling into the legal market. Not that that would be justified or acceptable, but then they would lose their license for certain. But can you afford this? Are you going to go under because of this fine? Realistically, tell me more about the economic impact.
One thing I guess I'd like to point out before I give it to Mr. Ali again is that the summary suspension and the requirements associated with that was pretty devastating impact on this particular business because they essentially had to destroy all their existing operations in order to get the suspension lifted. And as a consequence, they were unable to make additional sales over the following year up until rather recently. So that economic impact was substantial. And then as to the other questions that you had,
I guess it doesn't matter, but those plants were not, there's no way after I just got shut down 2 years ago for not having tagged plants that I'm going to have another 400 untagged plants in there and that they wouldn't shut me down that day. If that was the case, why was I not shut down that instant in that day? And you know what I mean? It makes no sense for that to even be said. you know,
And just to clarify, they were able to find the tags the same day, so that was taken care of. The tags were not with the product. There was quite a few of them. And I'd also point out, we have a very lengthy payment plan over 11 months, which is fairly significant right there.
So do you think this could put you out of business? Or do you think you'll survive this? I'm assuming if you entered the
I
settlement
don't know
agreement,
how I've
assumed
been
you'd
able to survive even up to this point.
True.
you know.
most of the businesses can't. Yeah. Okay. Okay. I think that's all the details I'm gonna probably get. Thank you, Chair.
We note for the record, and from my perspective, we have a plan of correction which identified things that were going to be corrected, indicating retaining counsel for various things and make sure they were in compliance. Also, understand the concerns of the licensee, but the requirement of operating within compliance for health and safety and other matters. This was an emergency suspension originally. And I understand the hardship, but, and unfortunately, it is what it is. Additional questions or concerns of board members? We have a motion in this case. I would move to accept the settlement agreement that's proposed and agreed to by the parties. We note the reservations, we note some of the mitigating circumstances, which is one of the reasons for the length of the payment plan that's attached to this. Motions for acceptance. Question is, do we have a second?
Mr. Chair, I second the motion with the comment that I trust that the attorneys are advocating to the best for their clients, taking into consideration the amount and the consequences thereof.
So noted. Any additional discussion? Move to second for acceptance. All in favor, please say aye.
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 Any opposed? Any abstentions? Matter carries. Thank you very much. Good luck, sir. We now move down to section 5, request for transfers of interest. The first matter up. Gravitas. Adam. TOI 22008.
Are you ready, Chair Douglas?
Do we have our applicants at least on the line or present? Please go forward.
Whenever you're ready, Chief Staley.
Thank you. Chair Douglas, Member Merritt, Member Durrett, Member Young, and Member Freilich. For the record, I am David Staley, Division Chief of Investigations for the CCB. I'm here to present item number 5, which consists of 5 transfer of interest or TOI applications. Item A is a waiver application by Gravitas Nevada Limited, which operates cultivation, production, and distribution licenses in Las Vegas, Nevada. Application number 22008 and later amended was filed requesting waivers of NCCR 5.110 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval of transfers of less than 5% of Gravitas ownership and agent card requirements for owners of less than 5% will be waived. Gravitas has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Gravitas 5.112 and 5.125 waivers to expire on its next agenda date. No areas of concern were identified during the investigation into this waiver application. I am available for any questions, and my understanding is that Alicia Ashcraft is available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Presentations for the record, council. Any statement you wish to.
Thank you so much, Chair Douglas. Good morning, and Director Klimas. Good morning, members of the board, and a welcome to Member Freilich in joining the board. My name is Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of Gravitas Nevada. As Chief Staley indicated, these are requests for waivers of NCCR 5.112 and 5.125. I just want to take a moment to especially thank Chief Staley for his assistance with these requests, really above and beyond the call, and also Investigator Dana Lauren for her assistance. I'm happy to answer any questions any of the board members may have on this item. Thank you.
Questions by members of the board? There being no questions by the board, entertain a motion for approval since there's no areas of concern.
Member Durrett, I move to approve the request for a transfer of interest submitted by Gravitas Nevada with the condition that the waivers granted pursuant to NCCR 5.112 and 5.125 would be set to expire on this licensee's next agenda item. How'd I do, Dave?
I think you nailed it.
We don't need Dennis. Just
That was perfect. Thank you.
Do we have a second on the motion?
I will second Member Merritt.
Moved and seconded. Any additional questions or concerns? Hearing none, all in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? None. Matter carries. Thank you, council.
Thank you.
That takes us to Redwood Warehouse. Do we have anyone present either on video or in person? With that, if we can go ahead with the presentation.
Chair Douglas, members of the board, for the record, my name is David Staley, Chief of Investigations. Item B are TOI applications by Redwood Warehouse LLC, which operates cultivation and distribution licenses in Las Vegas, Nevada. TOIs number 21049 and 2100033 were filed requesting a waiver of NCCR 5.110 pursuant to NCCR 5.125 and approval of several internal transfers of interest whereby several individuals' personal ownership will transfer into trust for planning purposes. The proposed sale by Leon Kermani of 10% of his ownership interest to a new investor, the Placid Group, will not occur, and Kermani's ownership will remain at 20%. This is a change from what was provided to you in the investigative report. Redwood's waiver request pursuant to NCCR 5.125 would exempt its members with less than 5% from having to obtain a cannabis agent registration card. Redwood has adequately addressed the items required in NCCR 5.125 to allow the board to approve such waiver. Staff suggests that if approved, the board limit Redwood's 5.125 to expire on its next agenda date. No areas of concern were identified during the investigation into this TOI application. I am available for any questions, and my understanding is that Amanda Connor and Harris Riddoff are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Ms. Connor, on behalf of licensee.
Good morning, Chairman, members of the board. My name is Amanda Connor from the law offices of Connor and Connor on behalf of Redwood Warehouse LLC. In attendance with me today was supposed to be the manager, Harris Riddoff. You guys have met him before at a prior meeting. He is an elderly individual, and unfortunately, he was rushed to the emergency room at 4 a.m. this morning, so is not in attendance. But we would ask that you continue and move forward with this transfer of interest. As Mr. Staley pointed out, this is transfers of interest and a request for a 5.125 waiver. The transfers that we are requesting approval are all estate planning transfers, existing members just restructuring how they hold their interest. Again, as Mr. Staley mentioned, the transfer of Mr. Romani to the Placide Group, we are requesting that transfer not be processed. I'm available for any questions. Thank you.
We know for the record that, as you said, it's internal, basically going into trust or limited partnership, differing things, you said. All the parties having been before the board previously. And just as a side note, we note that two of the brands that they have carry are the Willie Nelson's brands and Tommy Chung's brand. Miscellaneous questions by the board of either the state council as in this transaction.
No, I hope Mr. Ridoff recovers quickly.
Thank you.
If we have no additional questions, we can get a motion for approval with the appropriate verbiage.
Member Durrett, I move to approve the transfer of interest requested by Redwood Warehouse LLC with the condition that their waiver under 5.125, which would be granted, would expire on their next agenda date.
Motion for approval has been made. Do we have a second to that with the waiver requirements?
Member Young, I'll second that.
Been moved and seconded. Thank you, Dr. Young. Any additional questions or concerns? Hearing none. All in favor, please say aye.
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 Aye. Any nays, abstentions? Matter carries. Thank you very much.
Thank you. And thank you to Investigator Dana Lauren and Chief Investigator Staley.
Takes us to item C, Blossom Group LLC, TOI 22009. If we can have our report.
Yes, Chair Douglas, members of the board, this is David Staley, Chief of Investigations for the CCB. Item C is a TOI application by Blossom Group LLC, which operates cultivation and production licenses in Las Vegas, Nevada. TOI number 22009 was filed requesting approval for Hamid Roshan to acquire 45% of Blossom through his domestic corporation, U.S. Housing and Land Improvement, from existing member Kaivan Kermani. No areas of concern were identified during the investigation into this TOI application. I am available for any questions, and my understanding is that Adam Fulton, Hamid Roshan, Bahram Danesh, and Bobby Williams are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you for representations.
Good morning. Adam Fulton on behalf of U.S. Housing and Land Improvement and Mr. Hamid Roshan, who is appearing here as well telephonically. I'd like to thank staff for their assistance in getting this across the finish line. And if you have any questions, we're happy to answer them.
Just a miscellaneous, I take it everything working well under the previously agreed to management service agreement?
Yes, that is correct.
Questions by the board?
This is Member Freilich, Mr. Chair. I just have a question.
Please.
I note that there is a loan that's being forgiven as part of the transaction. Can you just explain that to me a little bit?
Yeah, absolutely. So Adam Fulton, for the record, Mr. Roshan had loaned the money previously, and in forgiveness of the loan, complete forgiveness of the loan, including any interest default, anything like that, to avoid litigation lawsuits, any of that. they agreed to transfer the interest to Mr. Roshan in his entity.
Okay, thank you very much.
Any other questions? If there's no other questions or concerns, or a motion to decide.
Member Durrett, I move to approve the request for a transfer of interest submitted by Blossom Group. There are no conditions, correct?
We have a motion. Do we have a second?
Member Merritt, I'll second.
Been moved and seconded. Any additional discussions? Hearing none. All in favor, please say aye.
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 Any nays? Abstentions? Matter carries. Thank you.
Thank you.
Moves us to item D. And NLV Organics, Inc., POI 18104, also known as Flower One.
Chair Douglas, members of the board, this is David Staley, Chief of Investigations for the CCB. Item D is a TOI application by NLV Organics, Inc., or Flower One Holdings, Inc. Flower One is a PTC that owned cultivation and production licenses in Las Vegas, Nevada through its subsidiary, CN License Co. 1, Inc. TOI number 18104 was filed in December of 2018, requesting approval for NLV Organics to be sold to a subsidiary of Flower One, CN License Co. 3, Inc. TOI number 18104 was subsequently amended to request approval for the unapproved acquisition of 50 million shares by Harry Azavian in September 27th of 2021 through a public offering or a private offering, and approval of the privatization of Flower One, which will result in Azavian owning 100% of Canna Nevada Corp. And all of Flower One's Nevada cannabis licenses. This TOI has been in process since August of 2021 after being placed on hold by the Nevada Department of Taxation's extended revenue review period in October of 2019. However, the various amendments to the original TOI, lack of current financial statements, and a complaint against CN License Co. 1 have all led to significant delays in processing this TOI. There are numerous areas of concern related to this TOI. Flower One SEC filings indicate that it acquired NLV Organics on November 9th, 2018, without required taxation approval. In September of 2021, Azavian purchased 50 million shares without prior approval. During 2020 and 2021, Flower One completed 14 separate transactions, resulting in the issuance of over 245 million shares without prior approval. And between 2019 and 2020, Flower One has attempted to pay its taxes with bad checks. I am available for any questions. And my understanding is that Charles Gianelloni, Salpi Boyajian, Kelly O'Keefe, Araxi Grant, and Harry Azavian are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. If we can have the representations appearing and also any statements that wishes to be made on behalf of the licensee.
Thank you very much. Charles Gianelloni, appearing on behalf of Canada. And then I have two people I just want to introduce here. Salpi Boyajian, who is the president of Canna Nevada. I have Kellen O'Keefe, who is the CEO of Canna Nevada. We have Araxi Grant, CPA, who is CFO of Canna Nevada. I have Katil Boyajian, who is Salpi's sister, who is the general counsel of Canna Nevada and also the director of compliance. And then, of course, the transferee would be Mr. Avazian, who is also just a brief statement. And we brought a lot of people here because this was a long process, and we assume that the board is going to have some questions. So I will just address a couple of things, and then I know you want to talk to them, so I'll I'll step aside. But just for some context, there were two sets of licenses in 2018 that were subject to transfers of interest. One of them made it in before the moratorium was imposed, and the Canada, Nevada entity through its subsidiary, that transfer was approved, and then the one that we're talking about today was delayed until today. So we've got one set of licenses was transferred back in 2018, and then the other one under a relatively similar set of facts is the one that's before the board today. So what sort of happened in between those 5 years is, I think, the majority of the areas of concern that have been expressed by Chief Staley and his team. For example, there was a 2021 conversion of debt to equity to sort of help deal with some of the financial challenges of the business. All of those shares are in escrow waiting for this board to decide final transfer of interest. In fact, the original 2018 transfer, or the consideration for the TOI that we're talking about, it's also an escrow waiting for this board's approval. There were certainly challenges with tax, and there is a payment plan that's in effect right now, and the company has timely paid those obligations. There is other money that's due and owing to tax, and we have been in constant conversations with tax and expect to hear back from them on how the extra money that's due and owing is going to be paid, whether it'll be rolled into the current plan or whether there will be something else. And those conversations are underway, just as there have been many, many conversations with the most recent investigator, Ms. Sandrock, with the CCB, as to the most recent restructuring that's happened, which was this restructuring to take Canadian parent company Flower One from public to private. So that is sort of the thing that makes this a little bit more complicated, is that arose as was accurately portrayed in 2021, and then finally at the end of last year, that restructuring finally happened. That relates to the transfer of interest for both the pending TOI for 2018 as well as the other one that was approved. So you've got a lot of different transfers here, and I believe that was at least the source of some of the confusion. However, I think the good news is when the dust settles, there will be one owner, right? And that will be Mr. Avazian. And he was the 35% owner of the company that's transferring the interest right now. So he effectively transferring 35% interest in a company he had, to where he will take 100% in a new company that he will own and control. That's the idea behind this transfer of interest. Now, in the middle of that was a public company that didn't work out so well, and we're happy to answer questions about all of that. But this is a person who, has been approved previously, and his interest is just going to increase, and it will be through a different one of the entities that for the board's consideration. And with that, I will step back.
This is Chair Douglas, for the record, interesting matter we have on us before us today. I'm not sure that we have enough information. What I am concerned about, this transfer seems to be, the most recent one seems to be correct. The problem is some of the past history. I don't know if we want to orally get into too many questions. And Impact is an outstanding complaint, I understand, which I haven't seen. And there's some other questions. So I'd like to hear the other members weigh in, see where they're at, if they have concerns or questions, whether they would be adverse to a conditional approval of this TOI, but yet referring this to staff to take a look at, giving us more information about what has been put forth in this, or whether or not that's something that we have to wait until the complaint is resolved one way or the other, so that you have your fair day in that representation. That's part of my concern. I don't want you to give us part and give something up that you don't want to give up at this point. So that's why I'm saying.
Member Durrett, for the record, I'm glad you mentioned that. So I know to also be careful. I also need more information because Chief Staley did such a good job. This report is so helpful. Thank you. But then I get to the response, and then I'm like, wait, and I need help matching them up. But that also could, like the chair said, be a part of another discussion. And because it doesn't seem like the transfer itself is the problem, because Mr. Ivajian has been vetted. So is there I guess, can I ask, would there be a concern with that transfer itself, Mr. Staley? And if we separated out any of the underlying conduct, there's no concerns with Mr. Ivajian becoming 100% owner, right?
Member Durrett, David Staley, for the record. No, we did not identify any concerns with Mr. Ivajian. And as council mentioned, there may have been a misunderstanding here. We understood that the transfer of shares related to the privatization of Flower One were placed in escrow, and as such did not identify that transfer as an area of concern. But I don't know that the company's response either was clear or that we fully understood that previous amounts and previous shares were also in escrow. And that's something that we can verify going forward. The other issues, the tax issues, the not sufficient fund checks, the secondary offerings and the rest, again, are historical issues. And we can do whatever the board directs. But the ultimate transfer of ownership to Mr. Ivajian himself does not appear to be an area of concern at this time.
That's really helpful, because I was having the same issues where it's like, wait, what? This is an escrow? Because that's kind of very important to know. And so I think all of the responses need to be coordinated with the report. So that's exactly what I need to know. Thank you. I had a couple of questions, but that it's Ivajian, right? That's how you pronounce it, right? Am I saying it right? Okay, thank you. That might be it. I have actually another question for Chief Staley. Just in general, if we're going to have to go through all of the machinations of what happened over the last 5 years, but if somebody submitted a request for a transfer in 2018 that hasn't been approved since till now, there really was no recourse for that, right? I mean, what could somebody have done to make that transfer happen throughout those years?
I believe that, David Staley, for the record, I believe that we've recognized that extended review period was very difficult for the entire industry. If you remember, however, we have multiple things that could have been done. We instituted the use of or approvals of the management services agreement, which would allow entities to have management oversight while the amounts themselves, or while the entities themselves stayed in the ownership structure that they have. I think that if this is referred back to us, we will look more closely at the escrow agreement. while the amounts were placed in escrow and the funds for payment were placed in escrow, the company did recognize and report the acquisition of the licenses and reflected their revenue and operating results as a wholly held subsidiary. I don't know of any other options available for Flower One with this kind of bifurcated process where one group of licenses was approved and the other was not. Unfortunately, that was the result of this extended review period.
Thank you. I do have more questions, but I do think they should wait. And I would be supportive of going forward, knowing that Mr. Ivajian's already been approved and that we will have time to consider everything else to happen.
Other board members with concerns or questions I wish to voice at this time?
This is Member Guzman Freilich. I'm not concerned with the transfer of Mr. Ivazian's current transfer. However, I am hoping that at some point that we are able to address the alleged violations that are reported in our in the materials.
Thank you. Anyone else for the record? If not, I would make a motion for approval of the TOI that is presently before us, which is TOI 18104. As part of our discussion reflects, also refer this to staff to come back to the board as appropriate. And also understanding there's a matter that's already with staff, a complaint that may tie up loose ends. I just don't. That would be my motion.
Can I make one more comment, Chair?
Yes.
I do want to see Flower One succeed, and I think it will. And it's been here since the beginning. They put their blood, sweat, and tears, investment, families, investment into it. It's family owned, and I want to see them succeed. So I would like to see that everything be as cooperative and everyone come together and work as well as possible to get everything set in the right direction.
Chair Douglas, this is Chief Staley. Could I ask a quick clarification before the board moves forward?
Yes.
Thank you. So if TOI 18104 is approved, then I believe that would take this TOI off the record. And if I understand it correctly, are you, and I would defer to Deputy Attorney Chris Rath, are you referring the issues back to staff and the Attorney General's office for us to evaluate further if any other if the violations had occurred and if a complaint is warranted? Is that the direction you'd like staff to take?
Okay, my understanding from the report was it is already existing. I wasn't sure whether some of the other matters that are embedded in the report have been properly reviewed. So we would refer it back to staff to see if there are other additional items that should come back to the board for clarification with a recommendation and waiting and also wanting to hear the outcome of the discipline complaint. It's convoluted. It's a little more than normal, but primarily one, the complaint that's just going forward. We're not taking it off the table or anything else. If there were matters that are outside of that complaint, though, that are brought up by this report, we would like for you to report back to us as to whether they should be looked at as a new complaint or in the alternative, it's something that staff and the licensees can resolve.
Chair Douglas, David Staley for the record. Could I suggest that you condition approval of 18104 to specifically address the ultimate acquisition of control by Mr. Azavian, and then refer the original application and amendments back to staff for further review?
If that verbiage is more comfortable, I'm fine with it.
And Chair Christopher Rath for the record. The complaint's a matter of public record. It does not involve TOI issues at this, so. We can look at that with staff if that's what's needed.
Just a coordination so that if there's something that's, as I said, outside of the complaint that needs to be looked at, and then a recommendation made, that we proceed that way, but not to hold up this transfer, because the suitability individually of the applicant is fine. There's some other things we're concerned with, but that's for another day.
Are you waiting for a second?
Yes.
Member Drat, I'll second.
Additional questions or in fact clarifications?
So my understanding is number 18104 is approved to the extent that Mr. Ivajian is going to now be the 100% owner. Any amendments or other potential transfers are going to be looked at by staff, potentially just for a status that where everyone's good, we're moving on, or potentially a status for a recommendation on moving forward on discipline.
With that being said, do we have a motion in a second? Any additional discussion or clarification? If not, all in favor, please say aye.
Aye.
Aye. Any abstentions? Any nays? Hearing none, matter carries. Thank you. And hopefully it can all be resolved quickly. Good luck.
Thank you.
Seer LLC. TOI 210001. 210002, 210004, 210005. Good morning. If we can have our report, please, and there were some possible areas of concern.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations. Item E is a TOI application by Seer LLC, which operates cultivation, production, dispensary, and distribution licenses in Henderson and North Las Vegas, Nevada. TOIs number 210001, 00002, 00004, and 0005 were filed requesting approval of 2 new investors and removal of a third. Seer also requested waivers of NCCR 5.110 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval of transfers of less than 5% of Seer's ownership and agent card requirements for owners of less than 5% will be waived. Seer has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Seer's 5.112 and 5.125 waivers to expire on its next agenda date. There is an area of concern regarding this TOI. As of the date of the TOI report, the Nevada Department of Taxation provided notice that Seer owned approximately $166,000 in delinquent sales and use taxes. On February 24th of 2023, taxation provided notice that Seer had paid off all amounts outstanding and is in good standing with the Department of Taxation. I am available for any questions, and my understanding is that Alicia Ashcraft, David Rosen, Irene Sirline, and Patrick McCormick are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Representations, please.
Good morning, Chair Douglas, Director Climas, members of the board. Again, Alicia Ashcraft of the law firm of Armstrong Teasdale. On behalf of Seer of Nevada and Seer of Las Vegas, with me here at the podium is CEO and manager David Rosen. By way of Zoom are Ms. McCormick and Ms. Sterline, the new investors in the parent company, Seer LLC. We acknowledge the area of concern as stated by Chief Staley. There were taxes that were due at the end of January when the matter was brought to us sometime in the second week of February. That was quickly corrected. And as Chief Staley indicated, we were able to get a letter of good standing last week and cleared up that matter as soon as possible. We apologize for the oversight, understanding the obligations to timely file and pay taxes. We're happy to answer any questions regarding that matter or any others that board members may have. Thank you so much.
Questions by board members?
Hi, Mr. Rosen. I think Mr. Rosen's very interesting. He's probably the only person in the cannabis industry who was a national campaign finance director. Is that it?
That is true. I mean, I don't know that I'm the only one, but
You're the only one in Nevada, for sure. I know them all. Again, somebody who's been here since the beginning, helped establish where we are now. So I see, and I love to see this. So Patricia McCormick, she's being gifted a percentage for
That's correct.
all of her work and loyalty. That is really
That's
great.
correct.
And she's also been there from the beginning.
day one.
We cannot say enough about Trisha. She's been instrumental literally from day one in 2013, 2014 when getting started. So if anyone's deserving, she
Yeah, I love to see that. It gives me goosebumps because there are the people who, like the general managers, stuff like that, who have put their heart and soul into it. And then at the end of the day, they're not the owners. So it doesn't always pay off as much for them. So that is great to see.
We plan to do more of that.
That is really, really great to see. I have goosebumps literally. Thank you. I don't have any other questions.
Any other
Mr.
board
Chair.
member please?
I just, again, I'd like to echo the sentiments too about the recognizing employees. I think that's wonderful, and I'm glad that you're going to continue with that practice. I just have a quick question as far as the processes and what kinds of processes have you put into place just to make sure that taxes are paid on time.
Thank you. It was an oversight. We're original licensees. We've been here since 2014 and we made a mistake. So our same team has been with us since 2014. Our CFO is in good shape. Trisha is a rock and someone we rely on. But we all make some mistakes once in a while, and that was an oversight. And we really apologize for this and understand and take our responsibility seriously.
And as a business owner, I appreciate that, and thank you for letting me know. We're just human, right? We all make mistakes, but thank you.
Thank you.
I actually have a disclosure. I should have made it at the beginning. Now it's going to sound bad since I said all those glowing things. I should disclose that I'd been retained by Seer prior to being a board member to serve as an expert witness. I basically opined on the transfer of interest process in Nevada, and I didn't obtain any confidential information that would in any way impair my judgment. I didn't obtain confidential information or anything that would impair my judgment.
We would so note for the record. With that, if there's no other questions, can I have a motion? GOIs?
Member Dret, I move to approve the requested transfers of interest requested by Seer Nevada. Looks like we do have conditions, right, Chief Staley? I would move that we condition upon the condition that the waivers granted pursuant to NCCR 5.112 and 5.125 would be set to expire on their next agenda item.
We have a motion for approval. Do we have a second?
Member Merritt, second.
And moved and seconded. Any additional discussion or clarity? Hearing none, all in favor, please say aye.
Aye.
Aye. Any abstentions or nays? Hearing none, passes. Thank you very much.
Thank you so much.
Thank you.
That moves us down to item number 6, request for consideration of approval of management service agreements. Understanding that item B on agenda today, premium products, is being held and will be on our agenda next month. With that being said, we go to item A, Conjurium 3.
Morning, board.
Chair Douglas, and members of the board, for the record, my name is David Staley. I'm the Chief of Investigations for the CCB. I would like to recognize regarding the Seer investigation, I'd like to recognize Investigator Rachel Prince. This is by far one of the most complex ownership structures I think I've seen in many years. And I'm sure you noticed that as well in the investigative report, and she did a phenomenal job. So thank you. Chair Douglas, members of the board, for the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to represent agenda item number 6, which consists of 5 management services agreement or MSAs. Item A is an MSA between Conjurium 3 LLC and GRN BAX LLC. This MSA has been entered into to provide for the funding and build out of Conjurium 3's proposed dispensary in Tonopah, Nevada. Judah Zakalik has common ownership of both Conjurium 3 and GRN BAX. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Judah Zakalik is present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Representations and statement.
Morning, board. Judah Zakalik, I'm chairperson for Conjurium 3 LLC, and also one of the managing members of Greenbacks LLC, the management company. Happy to answer any questions, and I thank staff for their diligence and questions and spotting any issues prior to this meeting today.
Here we note for the record, just generally on management service agreements, unless we really have some questions, it's really pretty much we recognize of the agreement and the relationship between the parties. But said that board members with questions in light of this particular management services agreement.
Member Drat, I can't say this for some and not all. Judah's been here since the beginning too. and he's owns a law firm, so this is no easy feat. So he's done great work.
Thank you. Also, I'd like just to say for the record, both Conjurium 3 LLC and Greenbacks Management are majority minority owned companies as well. So I'm very proud of that fact.
Thank you for saying that. I should have mentioned that or asked about that. Thank you for saying that. Member, would you like a motion?
Well, if you have something to say.
No, I can make the motion if you're ready. Okay. Member Drat, I move to approve the relationship between the parties that have been submitted relating to the management services agreements between Conjurium and Greenbacks.
Greenbacks, yeah.
We have a motion for approval of the management services agreement. Do we have a second?
Member Young, I'll second that.
And moved and seconded. Any other discussion or questions? If we have none, all in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Hearing none, matter carries. Thank you.
Thank you, board.
As indicated, item number B has been moved to the meeting for next month, which takes us to item C, Excel Brands Nevada, the third LLC.
Chief Staley, can you hear us?
Members of the board, I'm not sure if you can hear me. I've lost all audio, both in and out, I believe.
Must be the snow.
Do we need to take a short break to get our audio back and forth, put back together?
We need a break.
Let's take a 5-minute break to see if we can get this back and forth done.
I was gonna say, don't act like you don't know that I need a break.
Dave, this is Amber. Can you hear me?
Yes, I can hear you. For some reason, everything shut off. Can you hear me okay?
Yes, we can. Thank you.
Sorry about that. Yeah, for some reason I couldn't hear anything from you guys, and I didn't know if you could hear me. And it shows that the CCB microphone is shut off again. Can you hear me?
Yeah, I can hear you. We have
Okay.
the board room muted right now.
I'm sorry about that.
That's okay.
I think I'm back.
Thanks.
It's finished. We'll come back on the record this time. We'll come back with item number C, Excel Brands Nevada.
Chair Douglas, members of the board, this is David Staley, Chief of Investigations for the CCB. Item C is an MSA between Exhale Brands Nevada 3 LLC and Natural Medicine LLC. The agreement provides for Natural Medicine to provide management services and complete the build out of Exhale Brands dispensary license, but also includes the purchase of the dispensary by Natural Medicine at a future time. The appropriate TOI application was filed at the same time the MSA was submitted, and an MSA approval will allow Natural Medicine to start the build out of the dispensary before completing its purchase. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Adam Fulton, Pete Findley, Lindsay Clements, and Ellie Naito are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
We've had the representations for the record. Any statement, council or parties? Good morning.
Chair, Board, Executive Director. I'm Stephanie Smith here on behalf of Natural Medicine. I also have with me Lindsay Clements and Ms. Naito seated. We're here to answer any questions that you have.
For the record, Adam Fulton on behalf of Excel, and I have with me Mr. Pete Findley, CEO of Excel. We appreciate again staff working with us through this MSA, and any questions that the board has, we're happy to answer. Thank you.
It was inferred reference to build out. How long is that calculated to take, or do we have any idea?
Lindsay Clements for the record. So the build out will be ready. We're prepped and ready to go for April is what we're looking at right now.
Fantastic. Questions or concerns by any board member?
Can I make a comment? I'm not going to bring every agenda item back to myself, but the cannabis world is too small. I have my friend Stephanie Smith of 15 years, my mom's former attorney, and my former member when I was in the industry, Mr. Pete Findley, we had a great working relationship. So we need to get some new actors in this industry.
So would you like to make the motion?
Yes, I move to approve the management agreement submitted by Exhale Brands and Natural Medicines. We would approve the relationship, but not the contents of the agreement.
A motion for approval. Do we have a second?
I will second, Member Merritt.
Been moved and seconded for approval. Any additional discussion or clarification? Hearing none, all in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Hearing none, matter carries. Thank you very much and good luck.
Thank you.
Thank you.
That moves us to item D, MJ Distributing, C201 LLC. Our overview, please.
Chair Douglas, members of the board, for the record, I am David Staley, Chief of Investigations. Item D is an MSA between Vireo Health, Inc. and Caliente Partners Group, LLC. The agreement provides for Caliente to provide management services for Vireo's cultivation and production licenses, but also includes the proposed purchase of the licenses by Caliente. The approved TOI application was filed at the same time the MSA was submitted, and an MSA approval will allow Caliente to be involved in operations before completing its purchase. One of the members of Caliente, Michael Cook, has cannabis operations in Oregon and Washington. CCB staff is working with Oregon and Washington to get an update regarding Cook's operations in those states, and a full review will be completed during the TOI investigation. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Jared Kahn, Amber Shimpa, and Michael Cook are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Representation on behalf.
Thank you, Chair Douglas, Director Klemus, members of the board, Jared Kahn. I represent Caliente Partners Group. Me is Mr. Cook. And we just want to also make sure we thank Chief Staley and Investigator Warpack for their expeditious handling of the MSA and the TOI that will be pending. I do want to correct also Mr. Staley. Mr. Cook is also licensed in California, so we just want to make sure you put that into our response letter last month as well, just to make sure you have that for the record. There's a processing and distribution license in California as well, while you're looking at Oregon and Washington.
Note for the record, this is management service agreements, least so 5-year period, but you also have a TOI that you're filing.
Correct. The management services agreement self-terminates upon the approval of the TOI.
All right. Questions by the board?
Mr. Chair, Guzman Freilich, I have a question for either Mr. Staley or the applicant. There's a question as to whether the STO Industries Inc. Judgment was satisfied.
Member Freilich, yeah, so that was satisfied. We can provide follow-up documentation if you need it.
Thank you.
Thank you.
And at this point, we note that since the TOI is, that changes going forward with that will be supplied within that investigation. Any other questions, concerns?
Just add while we're waiting on that, Mr. Cook's operations in Oregon, Washington, and California have been operating for several years. No license issues, no fines, problems at all thus far. And we hope that you were able to access the link that was provided in the supplemental response that shows the drone flyover of their farm in Oregon, which is quite impressive. That's why I always like to point that out. Their operations out there. There's nothing else like it here. So.
We don't quite have the weather that Oregon has, even though we're trying up north.
What's great is Caliente has similar to the Louisville property conditions.
While members are notes, look forward to having you here in Nevada based on your experience in other jurisdictions. Hope that helps our industry going forward as a young industry. But with that, readiness of anyone to make a motion, still to see if they have additional questions.
Member Dret, I move to approve the request to enter into a management agreement submitted by MJ Distributing and Caliente Partners with the understanding that it's an approval of the relationship and not of the contents of the agreement, and that the board may be that they're related to the upcoming TOI. There will be an investigative report.
A motion for approval of the MSA. Do we have a second?
Member Young.
Member Merritt.
We have a trifecta for the second. With that, now it's been moved in second. I don't know where to give the credit to, but it's been second. Any additional questions or clarifications? Hearing none, all in favor, please say aye.
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 Any nays or abstentions? Matter carries. MSA is approved. Thank you very much.
Thank you, everybody.
Hopefully
Thank you very much.
a smooth TOI process. Takes us to item E, Greenscape Productions, LLC.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations. Item E are two MSAs involving Greenscape Productions LLC. The first MSA is an agreement between Greenscape and Mojo 2 LLC. This MSA provides for Greenscape to manufacture, label, package, store, and ship Mojo cannabis products. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. The second MSA is an agreement between Greenscape and Presidential RX Holding Inc. LLC. The MSA also provides for Greenscape to manufacture, label, package, store, and ship presidential cannabis products. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Paul Nimshuan, Rachel Shidaki, Ranson Shepard, Chad Wallace, and Everett Smith are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. If we can have representation for the record.
Good morning, members of the board. My name is Paul Nimshuan from Greenscape Productions, and I'll have everyone to introduce themselves. And after that, we'll be available to entertain your questions.
Thank you.
Thank you.
My name is Wei Chen, and it's Greenscape Production. I have to wait for you guys to answer the question.
If we can go just through first with just introductions of the parties that we have in front of us.
Sure. James Hammer for the record from Mojo 2 LLC.
Sean Kennedy for the record for Mojo 2 LLC.
Chad Wallace for the record, Mojo.
Everett Smith for the record, Presidential Holdings LLC.
Rachel Shidaki for Greenscape Productions LLC.
Thank you. Board members, questions, concerns, or?
I guess we have the time, so I will just mention that James Hammer has been here for the highs and lows of this industry. Some of the lows that come to mind are back in the medical days when there were no patients and it took 6 months to get a card. The jump to COVID when people were lined up around the doors and people could not stop people from coming to their stores. They physically could not stop them. So there's been it's been a fun ride, and James and his family have been here since the beginning. So it's cool to see you expand. Would you like a motion? I move to approve the management agreement submitted between Greenspace and Mojo. The approval would be as to the relationship and not as to the content.
So noted. Do we have a second?
Just remember, do we also need to agree to the Greenscape and Presidential, or is that all?
Yes, you do.
Oh, okay.
Yeah, I'm sorry, my motion would also include the relationship between Greenscape and Presidential.
This is Member Young, I'd second that.
Okay, we have a second to both MSAs. With that, any additions or clarifications? All in favor, please say aye.
Aye.
Aye. Any nays? Any abstentions? Both matters carry. Thank you very much, and good luck with this venture.
Thank you.
Takes us to item number 7, consideration for approval to extend final inspection deadline for Wendover. Wendover.
Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. Agenda item 7A consists of a petition by Wendover LLC. Wendover was issued conditional medical and adult use cultivation and production licenses within the West Wendover jurisdiction. Wendover first extension request went to the board at its December 14th, 2021 meeting, and it was granted an extension to February 5th, 2023. Wendover reports that while it had challenges in obtaining a contractor to work on the construction of the facility, it has recently identified a contractor. Staff have communicated to Wendover that there are areas of concerns and has asked that the licensee be prepared to discuss its progress at the board meeting. Staff concerns include Wendover has shown very limited progress since receiving its extension in December of 2021, other than indicating it has recently identified a contractor to work on the project. Also, Wendover's adult use cultivation and production licenses expired on December 31st, 2022, and it has not submitted an annual license renewal fees nor renewal applications. It has received notifications 60 days prior and 30 days prior to the expiration of the licenses. It also has received letters via email, mail, and certified mail on January 4th and February 1st, 2023. All mail correspondence was returned as not deliverable. CCB staff had a conference call with Wendover owner and its legal counsel on February 14th, 2023, in which the expired licenses and action needed were discussed. But as of today, no action has been taken by Wendover to pay the past due renewal fees. After the staff report was submitted to the board, Wendover did submit some supplemental documentation indicating they have engaged a contractor for the build out of the facility and intend on completed that renewal application. The supplemental information was provided to the board on February 27th, 2023, which was yesterday. I'm available for any questions, and Rebecca Gasca is available by Zoom, and Alicia Ashcraft is present to give in a presentation and address any questions you may have.
Thank you. Ms. Ashcraft.
Good morning again, board members. Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of Wendover LLC. As Chief Gilbert indicated, Ms. Gasca is available by Zoom. Regrettably, there has not been progress toward operational status for these licenses. This conditional licensee, I think, has been hit particularly hard by a set of circumstances that we've tried to illustrate in the letters and materials provided. First and foremost, Ms. Gasca is the sole woman owner of this business. She does have an advisory board that is, again, mostly woman filled, and had originally partnered with a woman-owned construction business to develop and build out these facilities. As we reported on the last extension request, that partner died due to COVID, and has been kind of challenging to find another person or group with which to partner, as was originally planned. It is especially challenging, as I've reported to this board before, when you have a rural area that's involved. There's just simply less interest in rural areas, and it is more challenging to find supplies and contractors and companies. In addition, the property that was originally identified, which was to be purchased from the city of West Wendover, was sold to another party. So we've also had to locate and find and identify a new location. We'll have to submit a location change request. Then most recently, as if those circumstances weren't challenging enough, it was brought to my attention, which I did not previously know, but Ms. Gaska had been the victim of a personal injury, which are the materials that we provided to you just yesterday. Part of the reason why that wasn't disclosed and brought about earlier was because there were confidential settlement negotiations that were going on. We're happy to answer any questions that you have about that. I don't know how much we want to go into those circumstances, but that was a significant event in Ms. Gaska's life, which caused her significant emotional and financial trauma. Her focus was in kind of getting her life back together following those events. That was very difficult to do. She's recently come to settlement on that personal injury, on those civil rights violations. Not to invoke the name of Maggie McCletchy, but I will because I'll take any help I can get. Maggie McCletchy represented her in that case. She still hasn't been paid on that settlement. I want to be clear. Settlement was just approved, and she hasn't received that check. So I hope that the board will take all of these matters into consideration. I would request that she be given just a bit more time. We just need to get the settlement proceeds so that we can pay the outstanding fees. I will also point out, and not to steal Member Durrett's thunder if she was intending on doing this, but I do want to point out that Ms. Gaska has too been involved in this industry in the state of Nevada from the very beginning. She has represented and assisted so many licensees in countless ways. This was her opportunity to be a licensee herself, and it has been fraught with complications and challenges that she has steadfastly tried to overcome. We ask for your indulgence, your consideration, and another opportunity to do just that. We're happy to answer any questions you have. Thank you.
So long and short, your party's ready to pay the outstanding fees necessary and move forward.
Yes, Chair Douglas, thank you. And if I could just add, once we get the settlement check, it was supposed to be paid last week. Our hope is to have those fees paid. So we would ask for just a little bit of time. Again, we should have received the check already and haven't. If we could request a little time of 30, 45 days to make sure we can get the check, process it, and get the fees paid, that is absolutely her intention to do.
The recommendation that's been presented to us is that your client would submit the renewal application, pay all past due renewal fees before an extension is granted. Past due fees are $13 and some change. I guess the real question for us today is, based on what we're hearing, whether we do this today with the understanding that before the extension is formally would go into place, the renewal application fees have to be paid. So you're saying that it sounds like in the next 45 days that will happen.
We believe so. Yes, Chair.
I'm willing to make a motion unless another board member wishes to ask any additional questions.
I have two comments I wanted to make. Member Durrett, for the record, one is I'd note that she's had the license since 2019, and we have, I think, granted extensions for licenses that were issued in 2014. But that brings me to a different point, which is I would really like to see some fleshing out of the regulations relating to these extensions. I asked for this, I think, like a year ago, but I don't know if I was very clear. I would like to see a proposal from staff putting some parameters on these regulations going forward, like defining extenuating circumstances, something like that. So we can have some, I mean, we have been consistent in just granting all of them. But I'd like to look at them going forward. We're gonna have ones that possibly will not be going forward, and I really want to make sure we're making the right decisions on those and have more definition towards extenuating circumstances. So again, I'd renew my request to have a proposal on that language from staff. And possibly for, I know we're planning on going forward with like receivership language, stuff like that. So I'd like to see a proposal on that around that time. So I would be supportive of however the chair makes his motion.
Make a motion to, we approve an extension to grant same period of time we've granted the others to November, but condition that they submit their renewal application and pay all past due fees before that extension is allowed to go into place. That would be the motion.
Member Durrett, I second.
Been moved in second. Any additional questions or clarifications or considerations?
This is Member Young. With the condition, is there a time frame set on paying the fees, or is it just extended until November 5th?
If they don't file their renewal and application, no extension can be granted. There's nothing to grant.
Okay.
So it's on them, but like all the other extensions we've granted, it's till November to keep it in line so that it doesn't fall between the cracks if and when it's granted. And we know Member Director's concerns because we've had that concern in terms of what we do. We know we have a number of categories of jurisdictional moratoriums, and for various parts of total vertical integration, or just non-cannabis and things of that nature. What we should do with that. But anyway, we have a motion, we have a second. Any additional questions? And thank you, Dr. Young.
No,
With
nothing.
that, all in favor?
Aye.
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 Any opposed? Motion carries.
Thank you so much.
That takes us to the executive chair's briefing. You may have some comments in terms of the regulation or taking regulations off per the governor, or any changes we're looking at this point, as well as our legislative session.
Thank you, Chair. Tyler Klimas for the record. So yes, it's just an update on the executive order issued by Governor Lombardo. So staff has currently identified a number of regulations that the board will review, and hopefully we will send to the governor's office for an exemption to move forward. A lot of these topics we've seen before. At least one is ready for board adoption. The others, if approved by the governor's office, would then go on our next scheduled workshop. In addition to that, per the instructions of the executive order, we are undergoing a comprehensive review of all of our regulations, identifying any regulations that might be removed, as well as identifying any regulations that may be streamlined or changed. All of that will end up in a workshop, likely sometime in April. We will have that workshop. We will solicit feedback from stakeholders, and that will end up in a report from the CCB to the governor's office per the requirements and instructions of the executive order on May 1st. So the board will have review prior, and then we will have a workshop in April to put the final touches on anything that we've identified since then. So with that, I can answer any questions on that process. That's the tentative time frame. With that, Chair, that's all I had.
Thank you. I have nothing to add to that today. We do note the request from Brett to get that done, and staff move on that appropriately. With that, our next meeting is scheduled for March 28th, 2023. Hopefully, the legislative session may be close to getting back in full swing and close to some resolution. the snow lifts. And with that, anything else for future agenda?
I have a request. I think it's the appropriate agenda item, although it's not for future agenda. Member Dret, for the record, I'd like to renew my request to have an advisory commission meeting on the legal market. The legal market. I had requested this, I don't know, maybe 6 months ago, I think, but I think we had decided not to do it for various reasons. So I now renewing my request to have an advisory commission meeting on the legal market, with the purpose being the industry has information to give, the board has information to give, and I'd like to see those parties come together and share that information and maybe come up with potential resolutions together.
Member Durrett, thank you. And as far as the illicit market goes, so we did create an advisory commission subcommittee. I announced at the last board meeting of the meeting before. So there'll be a subcommittee on the illicit market, which will eventually go to the commission. And so we're moving forward with that. So I appreciate those comments.
Thank you.
Noting that, we come to item number 11, public comment. Any public comment in Las Vegas? Any public comment up north or on Zoom? Hearing none, we are adjourned. Thank you.